Hello and welcome to Litigation Matters, Episode 2. My name's Stuart Clubb and I'm the Joint Head of the Scottish Litigation Services team here at Shoesmiths. Last week I put out the first episode in this new series of vlogs, the aim of the series being to look at developments in the world of litigation here in Scotland and to break those developments down into short, bite-sized chunks. And first of all, thank you to everyone who watched. If you did, then you'll know that I started the series by looking at the impact of Covid-19 on the civil courts here in Scotland. And by way of a brief update since last week's episode, the Court of Session's Covid-19 guidance note for practitioners has been updated, with the guidance now extended until 1st June, at which point it will cease to have effect unless it's extended again, although I don't think there's really any question or doubt that it won't be extended. Last week also saw the first virtual Sheriff Court hearing take place in a commercial case at Inverness before Sheriff Principal Pyle, and just yesterday Aileen McGowan and our team conducted a virtual debate hearing over WebEx at Paisley Sheriff Court. So more positive steps forward, and I wanted to share this quote from Sheriff Principal Pyle, who said, "There's still a long way to go, but the hearing this week is another step along a road which, over the coming months, should revolutionise the way in which Sheriff civil court proceedings are conducted." And I think that acknowledgement is important. These are simply steps. Look, no one's saying that the current arrangements are perfect or that there's not a lot more that the Scottish Court Service could or should be doing, far from it. But I think it is important that where progress and positive steps are made, such as with remote and virtual hearings, that's recognised. And I say that in part because one really interesting aspect to all of this is where this could lead and how it could change the way in which the civil courts operate in Scotland forever. And that's certainly something that we'll be keeping a very close eye on and following closely here at Shoesmiths in the weeks and months to come. And if we're talking about the impact of Covid-19, then we need to talk about the Coronavirus Scotland No. 2 bill, which was introduced in the Scottish Parliament last week. This bill is the latest piece of legislation introduced by the Scottish Government to put in place temporary measures to support and protect individuals and businesses from the financial impacts of the current pandemic, and it's expected to come into force before the end of the month. Perhaps the main change for litigators, and in particular those specialising in insolvency and debt recovery litigation, will be the change in the criteria for creditors being able to present sequestration petitions, with the minimum debt level being increased from £3,000 to £10,000. And this change has come about because the government recognises that one of the likely impacts of the current crisis is of course an increase in personal debt problems, and therefore the bill makes it more difficult for creditors to force someone into bankruptcy by increasing the amount that the debtor must owe to £10,000, thereby helping reduce, the government says, the threat of creditor-led bankruptcies. And it's important to note that this increase in the minimum debt level will also apply to partnerships, trusts and certain other bodies who can be sequestrated under the Bankruptcy Scotland Act. The policy memorandum accompanying the bill states that this measure, taken together with the earlier moratorium extension, will help to ensure adequate time for those who will be able to repay their debts once they've recovered from the immediate financial and economic shock caused by the crisis. Interestingly though, given what I've been saying about the courts, the policy memorandum also states that a secondary benefit of increasing the minimum debt level is that it will reduce the number of creditor-led sequestration petitions, allowing the courts to focus resources elsewhere. Ironically though, it's likely to be the fact that the Sheriff Courts have placed most cases on hold, which is providing the most protection to debtors at present, as creditors are simply unable to progress their actions. And finally, I want to talk briefly about what this bill doesn't do, and that's the fact that it doesn't introduce any additional protections for commercial tenants beyond the measure introduced in the Coronavirus Scotland Act, namely the extension of the period before which you can terminate a commercial lease for non-payment of rent from 14 days to 14 weeks. However, it was announced by the UK government back on the 23rd of April that as part of their Corporate Insolvency and Governance Bill, there would be a temporary ban on landlords using statutory demands or applying for winding up where the tenant company cannot pay its debts due to coronavirus. However, despite these measures being announced almost 4 weeks ago now, the government has still not published the bill and the protections are therefore still not in place. Indeed, I'm not sure it's terribly helpful to trail these measures so far in advance of there even being draft legislation, because they often raise more questions than they answer. Indeed, one of those questions is whether these measures will apply to Scotland or not. Responsibility for the law relating to winding up is divided between Holyrood and Westminster, with the grounds for winding up being a reserved matter for Westminster and the process of winding up being devolved to Holyrood. As such, it would seem to me that as this is a policy change affecting the grounds for winding up, It will be a matter for the UK government to legislate, but it may nevertheless still require some Scottish legislation if there's also to be a change to the process, such as has been stated, building in a review of the petition by the court to check the reason why the company is unable to pay its debt, and whether that's due to coronavirus or not. Again, we really need to see the draft legislation, and perhaps by the time of the next episode of Litigation Matters, the bill will have been published. That's it though for this episode. Take care, and thank you for watching.